Reporting live from floor 9, I Towers North CBD, we bring you a sip and talk session with Bookbinder Business Law. Joining us today, we have Daphney Muzila and Waona Segaetsho. My name is Ketshepaone Ngidi, your moderator for today. Now, in the past few days, there's been a lot of excitement about the new Employment and Labor Relations Bill. What is this bill about, Daphney?
Let me take a step first, because there's quite a bit. When one does take a glimpse at this bill, one immediately appreciates that it is a consolidation of three pieces of legislation. You have the Employment Act, the Trade Disputes Act, as well as the Trade Unions and Employers Organizations Act. That's the first thing. There is also a codification of the common law, that is the precedent that has been set by the Industrial Court and the Court of Appeal, now being crystallized into legislation. An example is the guidelines on a fair hearing, which were always in the Ketshepaone case. Now we see them in this bill. This usually happens when we want to create clarity and certainty. Another form of codification is in relation to the ILO standards that the Industrial Court has been jealously guarding and ensuring that they are employed. One of those is ensuring as an employer that there's no harassment in the workplace and that this workspace is safe from violence, and more specifically gender-based violence. No doubt this advances our policies in relation to the stance of the wider community against gender-based violence. Another thing that we see, which was always in our code of good practice, is the accommodation of disabled people by an employer. These have always been there, but putting them into the Act ensures that we rubber stamp the issue of inclusivity. So that's one of the things that you see. We also see a change in the range of penalties. We've always had penalties between 500 to about 20,000, but now we see a change that ranges from 2.5 to about 200,000.
That is quite remarkable, but I'm curious, does this include terms of imprisonment as well?
100% it does include that, because so far in the Act we have about 12 months imprisonment. We see now this rising to about 3 years imprisonment. That means that an employer could get into some serious trouble. And I think on the last point of some of the things we do see with this bill is that there is going to be an establishment of the Mediation and Arbitration Commission. It is meant to be a body corporate. And what that means is that it has the ability to sue and be sued.
So in the same way that a company is recognized as a person in law, so the corporate body is mentioned.
That is 100% correct, Waona. I'm not sure why that would happen, but that is what the bill proposes. Another thing that is interesting about this commission is that it is going to have an oversight body, which is the board of the directors that oversees that commission. More importantly, that commission is meant to be free from association or affiliation with political parties as well as unions.
Extraordinary. So, considering all this wonderful information, what would you say are the benefits that come with this bill?
Well, Daphney has mentioned that there has been a shift of focus onto gender-based violence-related issues. So I think I should springboard on that and then look at how this act benefits women particularly. So an example of this would be the change in maternity. So under the current act, maternity leave is 12 weeks, which provides quite a lot of time for a new mother to spend with her newborn. But under the new act, this has been increased to 14 weeks, which provides additional time to bond with the young mother. Now, in the same field, there has also been a change in the minimum salary that may be paid to a woman on maternity leave. Currently, it is 50%. But if this bill passes, that will change to 70%, which I think will please many of our listeners.
Commendable, considering that diapers are expensive.
Indeed, indeed.
Indeed.
Now, there's also been a look into fathers. So, as we know, fathers sacrifice a lot for their children. And recognizing this, the legislature saw it fit to include paternal leave, providing fathers time to spend with the newborn where necessary. And in the unfortunate event that the mother passes away while on maternity leave, then the father then spends the rest of that maternity leave with the kid. There's also been a change because previously, or maybe say under the current regime, where one falls sick during an annual leave, you lose that leave day. Now there's been a shift in the proposed bill where anyone who falls sick during an annual leave has that be converted into a sick leave, providing that the necessary documents are provided from the doctor. Another addition has been the family responsibility. Now, with family responsibility, as we know, the vicissitudes of life affect us all. And in recognition of this, the legislature has provided that where there is a funeral or an illness affecting one family member of yours, then you are entitled to a family responsibility leave that allows you to tend with all those issues. Lastly, we've focused on the leave days that accrue to biological parents. But there's also been recognition that adoption is very important socially. And so now the legislature is seeking to provide 10 weeks of leave to newborn parents, to parents of newborns. So where a child is under 2 years of age, the parent is entitled to 10 weeks of adoptive leave.
Extraordinary. What a very progressive bill. Now, considering what he has just said and everything else that comes in the bill, what would you say employers should look out for?
Quite a lot. I think one of the leave that has been added into the bill is something along the lines of trade unions. Waona.
Oh yes, that's very true. So with regard to trade unions, there is a recognition that trade unions require their members. These members, of course, are employees of given organizations. So where an employee who is a member of a trade union has to do certain trade union activities, then the bill provides them a certain number of leave days at the discretion of the employer to be able to fulfill those.
100%. And just to add on to that,
Yes.
from the employer's perspective, that means that an employer has to make provision for these leave days financially, because you now actually have a bit more of leave days. So you're looking at the maternity leave, the paternity leave, as well as the trade union leave. That's one of the things that an employer has to make provision for. Another thing that an employer has to make and look into is the retrenchment provision. Retrenchment has always been there under Section 25, but what wasn't there was the guidelines. They've always been in our common law, so now they've been codified. An important aspect that has now been added in this bill is the requirement that if during a consultation in the retrenchment process, the parties do not agree, that is the employee and the employer do not agree, they are now mandated to take that issue to the mediator. Now that may possibly create a problem, and I will address that problem on two levels of analysis. The first one is that we need to understand that it is the prerogative of management to run its business and to decide on what the operational requirements are. Now, and they are also then required to consult. What it means on consultation is that one must then get the ideas from employees, get their views, and then have the final word. So when we add the issue of agreement and failure to agree, it means that it takes it away from the purview or from the realm of consultation to the realm of now negotiation. So that's the first level of analysis. The second one is that if you take the issue to the mediator, it then brings the question of how much should a mediator engage or encroach into the discretion of a manager, into their operational requirements. So those are some of the things that an employer needs to be on the lookout for. Another thing is that now the Act ensures that part-time workers have the same rights as full-time workers. What that means is that if a full-time worker has a specific benefit that accrues in a month, that a part-time worker also has that right, but it is proportional to the number of hours that they put into the work. Then another addition, springboarding from that one, is fixed-term contracts. Fixed-term employees now have the same rights as permanent employees, also on a pro rata basis.
Wow, that is certainly a lot to adjust to for both employees and employers. It will be
100%.
very interesting to see how this bill gets interpreted
Mhm.
on the ground. Now, do you think that there are any gray areas?
Well, I think I should begin with whether it's the employer or the commissioner that runs the company. But other than that, I think we can zero in on two gray areas. So the first relates to overtime, where under the status quo, overtime entitlements do not accrue to managers, administrators, or professional staff, or similarly situated employees. However, under the new proposed bill, there has been an exclusion of the aforementioned provision. Now, in its stead, the legislature has included a provision that says members of management shall not be entitled to overtime. This then raises the question, am I, as a junior attorney, entitled to overtime leave in the event that I spend the night at the firm doing an urgent application? Now, of course, I would love that, but it remains to be seen whether that is the intention of the legislature or whether this is something that will be clarified in due course.
And that would be you as a professional, as the act stands now, and maybe we should just call you a manager then.
Precisely. Precisely. And I suspect many employers will do that. In addition, there might also be a need to reduce the basic pay of non-managerial staff to adjust for the additional pay that accrues in the event that they work overtime. But other than this, there also is trade unions. Now, the current law on trade unions is crystal clear. As we know, a trade union that represents 1/3 of the employees of an organization are entitled to recognition. The bill mirrors that requirement. Where it shifts comes in at the apparent attempt to include an exception. So under the bill, despite the 1/3 requirement, where a trade union, and I quote, represents more than the workers of an employer, then the need for recognition subsides. This raises the question of whether this more is more than the 1/3, or is it less than the 1/3 but more than a fourth, a fifth. If at this stage the audience is confused, they should take comfort in the fact that I am too.
I am just as confused, and I think that one might require more clarity because it does not set what the yardstick for more is. If you're saying more, are we saying it's more in terms of in relation to other trade unions or just more employees? So I think it stands to be interpreted by our courts or maybe taken back to the legislature to be considered.
Precisely.
Wow, what an extraordinary discussion about what is happening in this bill. Thank you so much for joining us, and that was some hot tea.